Welcome to the Small Business Big Insights podcast. Today, so excited to share this episode with some big insights from our very special guest, Margot Pomerleau, who shares with us some key strategies to protect your business, avoid some contract pitfalls, and manage your client relationships with confidence. I invite you today to subscribe to the podcast, and otherwise you're going to miss out on one of our upcoming episodes. And also give us a nice review on your podcast platform of choice. It helps us spread the message. So today we're joined by Margot Pomerleau. Why don't you tell us a little bit about yourself?
I am a lawyer practicing here in
Nice.
Ottawa.
Okay.
I practice in the city, but everywhere in Ontario and Western Canada.
Okay.
So I practice in a what some would call a boutique litigation firm, providing services and a whole range of legal services that we'll talk about, I'm sure. But I'm from Eastern Canada. I'm from the country. I'm from a rural area. Moved to Ottawa, and so a little bit of a chameleon in a sense that some people might think I'm a city girl, but I'm really not, which helps me in my practice of law.
Yeah.
But I've been practicing law for over 15 years. I'm a partner at the firm.
Yeah.
But it's very fun to be here sharing some of my insights and my experience with you. I'm looking forward to it.
Awesome. Cool. Yeah. So you have a firsthand kind of knowledge of how Suits the show is so inaccurate, right? Because that's kind of what you do, but I'm sure the show is just, not real.
Exactly.
Cool. So the truth is, like, you do a lot of litigation, right? Which is very different than like a, real estate lawyer or a corporate lawyer. And so it takes a certain personality to do that.
Yes.
Right? Like you're stirring up the pot. Like you're the one aggravating kind of the situations, right? So what kind of person do you think you need to be to be in your kind of position?
It's an interesting question, but a fair one. I think you have to be yourself in all of your practices.
Sure.
But I think you're a different person when you walk into a different room. And I think a lot of lawyers and a lot of professionals don't feel that and make conscious decisions about that as much as a civil litigator does.
Okay.
You have to know what room you're in and how to work that room. You should always be yourself, or you don't have longevity in the practice of law. You can't, it's not maybe fake it till you make it, but you obviously don't have sustainability on being somebody else. But it's that ability to be able to assess the room that you're in, who's in that room, and how to work that room. I'm obviously a different person than I am with you here speaking than I would be walking into the Court of Appeal or walking into the Superior Court of Ontario, walking into a mediation, into an intake meeting with a client.
Right.
That client is different if it's a small business owner, a first-time business owner, somebody who's just lost their business, a bankrupt, an estate litigation case, somebody who's just had to let go an employee. And, there are different rooms. And I think a good litigator, and I think some of the good skills that I have are probably in knowing that environment that you're in and suiting your skills to that environment. I think that makes a great litigator.
Interesting. Yeah. So trying to be yourself, but also kind of like be the person that's needed in that environment for that person, right?
Yeah.
And you're their fighter. You're there to help them through that legal process, right? So you have to have their interest at heart.
And depending on who the client is, sometimes that's reining them back and being like, whoa, no, we are not taking that step. That is not a good business decision, nor is there any merit whatsoever in law. We should probably not do that. Yeah. And sometimes it is, like you say, being the aggravator and standing up for somebody who may not have the ability or the skills or the talent, obviously, to be able to stand up for themselves in that legal situation that they find themselves. Right. So there is a balance there of sometimes I am stirring the pot, but then sometimes I'm taking the pot off the stove because it's boiling and we need to put the temperature down.
Yeah. People get overly excited, and I'm sure the nicest position that you can be in is to help kind of like the little guy like navigate through the world when they have a true good case and all of that. But I guess like it's got to happen that people approach you and you just like don't agree with them, but they have a legal case and you have to like argue their perspective because they do have a point, but technically like you don't agree with them, like you don't like them, how do you work with that? Like,
Well, the bad guys are allowed to have legal representation too.
Right.
You don't have to be the good guy. You don't lose your legal rights once you become the aggressor. That's not how it works.
Right.
So even the good guys make mistakes. And even, we often say, white hat, black hat. You can have the white hat, but have like no legal basis to the position that you've taken. Like, I know you were trying to do the right thing, but you didn't. Stupid. And sometimes you are the bigger corporate entity, but you followed the rules. And and then you should have representation in court for that. And I think that it's a way that I can legitimize, being able to stand up in court or being able to represent an entity or a person that maybe personally I don't really have any interest in spending time with them. But because their position has legal merit and they have a right to their day in court and they have a right to be represented and they have a right to have their invoice paid or have a right to fire who they want to fire, you're allowed to do that as a business owner. You just have to follow the rules. So I think that that's kind of how I address those types of clients.
Yeah, that's fair. That seems reasonable. And I guess like you deal with a lot of, whether that's medium-sized business, small business, big business, but for a lot of business owners, what's a very clear legal advice you'd want to give to people here? And maybe advice is the wrong word because, there's potential liability.
Yeah, we're doing a little asterisk. This is legal information and based on my experience and not legal advice that we're providing here on the podcast.
It'll be in the show notes.
Yes, exactly.
So what do you think that they don't want to hear or that they absolutely need to hear as a business owner?
Right. So the first is you should get a lawyer. People really hate hearing that. So, just generally speaking, I'm not usually the one giving them that advice.
You should hire me or someone like...
You should hire me or something like me. If you don't want me, that's okay. But you should probably seek legal advice. I'm usually giving that to people on the other side. Like, should probably get a lawyer in this circumstance. But I do think that even small business owners and medium business owners, because they are so passionate about their work, their business, whatever, if that's, manufacturing, service providers, professionals, artists, craftsmen, whatever it is, tend to ignore paying for an accountant, paying for a lawyer, and paying for either good insurance or good coverage, informing themselves with a regulator or their association. They want to focus on their business, and I appreciate that. That's the goal, that's their passion, and most likely their way of living and supporting their families. But I think that people don't like hearing, well, you need to have a lawyer to properly fire someone if you have never done that before. You probably do not have the skills or the knowledge to properly fire someone, an employee, a contractor who should be dismissed. And if you do this wrong...
There's like one wrong word.
There are going to be consequences, and then you are going to require a lawyer. And my biggest, one of the things I dislike but also appreciate is a client who comes back after not following my legal advice 6 months later and saying, remember when you told me that it would be high risk to take on this project? I was like, yes, how is the project going? I hope it was as financially successful as you had hoped. And they're like, no, remember when we flagged these 4 risks? Yes. Well, 2 of those have come to light.
Oh, God.
Oh, you would like to repay me for my services? Well, this is my retainer. And they're like, well, that's triple what it was before. I was like, yes, it is. Correct. I think we discussed that.
It would have been cheaper to hire me before.
It would have been cheaper to hire me before and to take those initial steps.
Actually listen to my advice.
So I think that a lot of people ignore, that first little $500 or $1,000 to set up a good corporation or get good advice or even sit with a lawyer for an hour, is an opportunity to be able to line yourself up for success. And a lot of business owners don't do that. And then there's a lot of, obviously, pitfalls that are a consequence to that.
Yeah. I mean, speaking of consequences, like what would you say is the most common legal mistake that business owners do? I mean, would you say it's about like not talking to the lawyers early enough, or is it like not getting a lawyer to incorporate? Like, I don't know, like I'm trying to hear it out.
I think there are maybe a couple of branches of that, but the first one is not putting pen to paper about a plan. A lot of business owners are thinking about their business and not writing down what it is that they have just decided with someone, writing down what it is that they just agreed to do. And that intention or that plan or that goal or that deal gets softer and grayer and looser as time goes by or as issues happen. So
people misremember what was said.
You can make a handshake deal. A handshake deal is a deal.
It's legally binding.
Legally binding. You made a deal. I'm okay with that. But to go back 6 years later on how you created a business with a partner on a handshake deal, and now your partner is, stealing money from your bank account or, not properly, abiding by the deal that you had that handshake deal with, it becomes harder for me to be able to defend your legitimate position.
Right. You can't point back to the conversation.
Correct.
Yeah.
And nowadays we have tons of tools that allow small businesses, just like large corporations, to be able to put pen to paper. Is it better to hire a lawyer? Yes, yes, it is. And that is a way to put pen to paper, is to have an actual agreement signed up. Of course. Yeah. But it is a way to, write yourself an email, text yourself.
Oh, I see.
Send an email to your new business partner. Being able to.
It doesn't always have to be a contract. It's just something in writing that all parties got.
Something that's going to memorialize what's happening. I'm not saying like post it on Facebook so we can all see it forever, or post it on Instagram or whatever social media that you have. Yeah. But there are tons of ways and tools, keep a journal, keep a calendar, take notes, put it in your Outlook calendar.
Right.
Being able to put pen to paper on what's happening in your business as your business grows is one of the biggest mistakes that business owners
it's interesting what you're saying too, that it's really not just about contracts, because it's like if it's in your meeting invites in your calendar, like that's technically you wrote it down at some point, that did probably happen, and then there's an email, even if it's like an email to a colleague that something happened, it's like it's been written down, like there's something there. It's not just going to be contracts or no contracts. It's like, what evidence do you have? And it can be all types. It can be a voicemail to your spouse about something. It can be, that's super interesting.
It is. And it's, you may have a lawyer who have said, well, that's great. We're just going to do these steps. Those are all the CAS steps that we're going to do. And then we're going to go here. And people are like, well, what are we doing? I was like, well, we're covering your ass. That's what we're doing. Like, that's what we have to do.
It's part of the process.
It's part of the process. But that's not the reason why you're putting pen to paper. Yeah. Those cover your butt types of situations are so that you can recall what the deal was or what happened. And also just as a peace of mind. Yeah. You have so many things going on as a business owner, and some of those things are priorities that you need to do. Some of those things are things you want to do. And it's the stuff in between. Yeah. Where I see the most risk, where clients are coming up.
And I've definitely seen situations where like I was a little bit, upset or about a situation. And then I go back to like the email that I sent to the person. And I'm like, you know what? The person's right. Like what I said in the email is not what I remember. Yeah. And then it's like, okay, well, what I wrote in the email is what I meant at the time. I'm just misremembering, like, right. And so it's really helping your own case to be like, okay, I didn't actually mean that. Or like I misremembered. I don't really know what the situation was.
And again, depending on what kind of business that you're in, you may spend tons of time with one client and have tons of different types of correspondence. That might be in person. Maybe, you're designing, maybe you're designing a business, maybe you're designing a house. Yeah. Even in the agricultural farming business, unlike us, a lot of people are not in front of their computers or in front of technology all day. You are out in the field doing something. Think of artisans, think of people, out, and I'm not just saying out doing cash crops or out doing farming, but a lot of people are not.
Like in the trades or in the plumbers or whatever.
For security purposes, you don't have your cell phone with you, or because of the environment that you're in, like underwater or, in a plane. Yeah. But even in those circumstances, you should take the time to, at the end of the day, okay, well, today I met so-and-so, the architect who said this. Today I met a representative of the city. Yeah. I met a representative of the Conservation Authority. I met a representative of my licensing body. I met George, who was the guy who was going to dig the hole for me, and just be able to confirm what that person said to you, what are next steps. Putting pen to paper in whichever way you are comfortable, putting pen to paper is probably one of the best recommendations.
Love it. Okay. Well, obviously, if that doesn't go well, sometimes you got to sue someone.
It does. You would be shocked how often that happens.
I can tell you, I've never sued anyone. Okay, not yet.
Not yet.
And so, I don't. To be honest, it's a bit daunting. Like, I don't even know what are the next steps. Like, how does that even work? Like, you're upset with someone. Maybe there's some like aggressive emails between each other about that escalates, and you're like, wait, that's not what I understood. Like this and that. What's the next step after that? Walk us through it here.
Right. So if you are ready to pursue your legal rights in court,
whether you're the good guy or the bad guy,
and sometimes you're both right, and sometimes I assure you, you are both wrong. All of those scenarios could happen. Yeah. But if you want to have your legal rights tested in a court of law, it's mostly paperwork. You retain a lawyer or not. You can represent yourself in small claims in multiple jurisdictions. You can represent yourself. I don't recommend that, but you may, and you have a right to. Business choice there. But you issue a claim. Now we can do that through a portal. Okay. So there's a particular form pursuant to particular laws in Ontario, how you start a legal action. And then the lawyer fills in what your rights are, what you are claiming, how much money or what kind of, if it's a property right that you want a declaration about, or if you would like some sort of injunction, somebody to stop doing something, or somebody you would like to act and do something. Those are legal rights that you have that you can impose. It's not just chasing money. Sometimes it's about other things. And then the documentation is issued in court and stamped with a nice little electronic seal now, because it's in a portal. We don't do the fancy wax seals anymore. Oh, no. And then you have 6 months to be able to serve the other side, the defendants. They don't automatically know. Like on TV, like you've been served and
show up.
That's it. Yeah, we don't pay extra. You got to pay extra for them to be in costume, so we don't necessarily do that very much. But then the service is how you give notice to the other side. Yeah. So you might be in a business dispute with somebody who hasn't paid an invoice, and you say, well, look, I'm just going to have to start a claim. And eventually that individual will receive that nice shiny paper with the little seal and the number on it. Yeah. And they'll receive it. And then they have a certain amount of days to be able to respond in writing, in a form, on paper. This is not This is not television. Law is slow and boring. Okay, this is not an $8,000 suit. Okay, it's not what you think. I don't think there's whiskey under here.
So I don't know.
Sometimes there is, though. Sometimes there is. But it's basically an exchange of, we call them pleadings on. Well, I owe you this. Oh no, but I don't because there's a deficiency in your work, or I don't because I've already double paid you, or whatever defense it is that the other side has. Okay. Sometimes there's a counterclaim or cross claim, depending on how many defendants that you had. So you receive a claim as a business owner, like, oh my God, I'm being sued, but this guy owes me all of this money, or that job didn't go well.
Both owe each other, so then it's like, okay, well, like,
You express that in writing, in the court documents. And then it's working with your lawyer on being able to demonstrate in evidence. Again, it's not television. Evidence is very boring. That's usually records and documents. So if you've done your job by putting pen to paper, it will make your lawyer's job a lot easier. exchange of emails, the amount of emails that we see. But,
Terrific.
plan, order forms, invoices, those types of documents, you will have to disclose all of that if it's relevant to your case. And the parties exchange documents, of course, using a form.
There's always
a form.
Yeah.
Just in case you were wondering. It's a very specific type of form. And then you exchange usually a document evidence. And then in certain circumstances, you'll be asked to provide oral evidence in examinations, all out of court. None of that is in court yet.
Is that a deposition? Is that what?
Examinations for discovery in Ontario, but same thing. It's recorded. It's not on video. And so in Ontario, and then it's not the audio that becomes the, fun fact, it's not the audio that is the evidence, but it's the written transcript.
Oh, okay.
Again, that goes to paper, Eric.
Yeah.
All about the paper.
So you got to review the transcript.
Correct.
Correct.
You don't get to hear yourself and your evidence. You have to read yourself and your evidence.
They're like, oh, I did say that. Oh, God.
And throughout a lawsuit, you follow through in that legal action, different exchanges of the evidence, paper, examinations, sometimes affidavits. So you'd swear a statement. Those get exchanged. And there's multiple opportunities to make a deal and to settle. More than 90%, 95% of cases settle out of court.
Yeah, because it's evidence to like both parties at one point where it's like, yeah, I don't have a leg to stand on, or
usually it becomes evident to the lawyers. Yes, it's convincing the clients.
That's the hard.
You no longer have a case. That was great when you told me this is what the story was, but
you didn't tell me this other.
As you may recall, this was not part of the story when we started this.
Yeah. So when you first do the filing, do you have to have your defense or not defense, but like your argument fully laid out? Like, can you, come up with other arguments later, or like, you're like, oh, this person stole from me, and it's like, well, they didn't really stole, they borrowed, and then it's like, the nuance goes later. Could it hurt you if you forgot to include something in your initial submission? Like, okay.
It's a very good question. Certain things you have to start within a certain timeline, which, is something that we can jump into. But one of the largest mistakes that small business owners do is kind of play the ostrich and stick their heads in the sand and ignore a problem. I don't have time for that. I don't have time.
Just ignore it.
It's fine. I'll deal with it later. When you have time. Yeah. As a business owner, when was the last time you had time to do something?
Exactly.
That's like the painting on my wall that I want to put up. It's like, I'll do that when I have time. No, I'm not going to have time to do that. But ignoring a problem might mean that you lose a legal right to enforce it. And so waiting 6 years for an unpaid invoice that you've never followed up with is, the chances of you having a legal right to enforce that invoice are almost zero. It's not 0. I guess it depends. But usually in Ontario, you have a 2-year period of time, a limitation, we call it, period of time to be able to pursue a right. There's exceptions to the rules. And in Ontario, you can plead in the alternative, which kind of brings me back to your original question. A lot of jurisdictions in the world, including many states in the U.S., you, depending on what you're asking for, have to pick a certain legal right that you are enforcing based on certain facts, but no alternative. What you're asking for is relief, is what we call. Well, in Ontario, you can plead in the alternative. You stole this. In the alternative, you mismanaged the funds. In the alternative, you were just kind of negligent. So you're able to recommend to a client that, look, based on this fact situation, these are avenues that we can use to be able to recover for you or enforce your legal rights in the alternative. But there are timelines on some of those pleas. Again, you can't
miss that.
Which is why you should completely disclose things to your lawyer. It's under solicitor-client privilege. It's a very good idea to just tell us the truth.
Yes.
Tell us what you recall. Disclose all of the documents and all of the emails.
That's true. Yeah. Anybody who's worked with lawyers before knows you should just tell them everything. Like, I think it's a rookie mistake to kind of like hold back information from your lawyer. Just like, oh my God.
I'm
Like that's the worst.
I'm going to
Like,
out-strategize the person whose job it is to set up strategy. Yeah, it seems like a great idea. I mean, it's an idea. It's an idea. You can try it out. But even starting the practice of law, I had a very wise senior counsel who, when we first started, used to sit you down and used to say this as when you start off, there's only two rules that are really important, the first one and the second one. And we used to think he was kind of a cynic, right? And it's like, well, the first rule is everybody lies. Come on. The second rule is it's usually your client. And is it a cynical way of looking at it? Yes, because they're not lying and they're not doing it on purpose. Again, as a business owner, you have so many other things going on that you forget about the second lunch that you had to discuss what the term of the agreement was.
Right.
You forget that you actually signed that other document that meant that you were allowed to use another service provider for something.
Mm-hmm.
You forget that you told that employee that they could have the extra 2 weeks of vacation or whatever it is that happened.
Yeah.
There's so much human error happens to all of us.
Yeah. And you kind of hope the other person forgets, like on the other end. Like if so then it's like,
yes.
But either way, you should say the whole thing.
These things are going to come to light. If you recall these things at the time, you should disclose those things to your solicitor at the time.
That's very fair. And I guess in this whole process, the person that's, let's say, starting suit has to gather all this evidence, has to, understand why they're wanting to sue the other person. So gathering all that stuff, like going through all your emails and everything, sounds like a lot of work for, in this case, like a business owner, right? So what's the litigator's job in all of this, right? Because I see the pain and suffering of like having to go through boxes of stuff and old servers and emails and calendars. And that seems like the hard work in a way, right? And then, so what does the litigator do in all of this?
We act at first as a filter of all of the evidence, but also all of the potential claims. So you have a problem. Let's identify what the problem is. Let's see how we can solve it. Let's avoid court. Let's avoid legal action. Let's avoid that and try to find solutions. And if we're crunched for time and we have to start a legal action because that's the only way to protect your rights, great, let's do that. But you come in with your boxes, your shoe boxes, or, your share drive that you've just sent reluctantly that has the terabits of information in it.
Yeah.
But it's it is for the litigator, for the lawyer to filter what is relevant and what is not. Mm-hmm. And I think some of the mistakes that a small business owner might make is, they're only going to need these 3 pieces of paper or these 4 emails. They'll never need these. Mm-hmm. Again, when as a small business owner, you do not know what is the appropriate test, appropriate evidence to be able to defend your legal rights.
Yeah.
And using that filter is time consuming. You might as well just like throw it all in a box and send it to me and then have us filter it. The lawyers filter the evidence to what is relevant in the claims.
Yeah.
The lawyer usually, hopefully, also focuses you on what are the best aspects of your claim, what is the best relief, narrowing down issues. Also in negotiating with the lawyer on the other side, being able to have candid conversations about the best and worst aspects of each of your cases.
Yeah.
The lawyers are there to find a solution for each of their clients, but we're not there to prejudice the other side. I have professional obligations. I can't do that. I'm not burning documents in a bonfire in the backyard. I'm not allowed to do that. I have to be fair to the process.
Yeah.
And I think that the litigator's job is not only knowing how to fill in all of the forms and filing them on time, which is very important, very important, but being able to think out of the box sometimes. I have tons of business owner clients who, during the litigation, one of the solutions we found to the problem is making another deal with the other side. Do you want to work on another project? Sometimes
we can all make money on that.
Why are you paying lawyers? Why are we here? Yeah. You could just be making another job.
Yeah.
You could do something else, or maybe let's walk away and why don't you just do another project,
Yeah.
make money, as opposed to spending money on
Let's
this.
forget all of this. Move on. We kind of still get along, so let's just
Correct. You like their work, they like your work. You just this project went like sour.
Yeah.
Okay, let's rekindle that. Which is, I mean, that's not in the law. That's not in rules of civil procedure.
That's true. Yeah. There's the practical side.
The practical side, like you're running your business here. Focus on what's best for your business.
Yeah.
To continue to pay me and to continue to pursue your legal rights on what? On principle?
Yeah.
Maybe. Unlikely the best business decision, but that's up to you.
Yeah.
And I think that that's part of the job of the litigator is to say, I didn't live through what you lived with. I didn't go through that, that situation. I didn't have to fire that employee. I didn't have one of my business partners pass away. I didn't have a real estate deal go sour. I didn't have a manufacturing plant ruin, the production of whatever item that I'm taking.
Yeah.
I didn't have a fire in my facility where all of my art or all of my work has been destroyed. I didn't have an insurance company who denied me coverage. I'm here trying to assist that. I didn't live through the emotion of it. Yeah. I'm here to parse through the evidence on what's your best chance at recovery. What's your best chance at getting what you need to go back to doing what you want to be doing.
Yeah.
No one wants to spend time with me.
Yeah.
I mean, I'm pleasant, but I mean, that is not... So I think that that's the job of the litigator, is doing their job with the court, being an agent of the court, filling in the forms, representing your client, advocacy, but also just trying to get them back to their business as best that they can.
Right. And I guess like as a professional, like there must be an underlying anxiety of like the client gave you 10,000 documents and there's that one document that you missed, that would have done X, Y, and Z or whatever. And it's like, it's impossible for you to thoroughly go through each and every document. And then later on, the client tells you, well, I gave you the document and you didn't even do anything. But it's like, yeah, but that was one of 10,000 documents, right? Like, do you have like an underlying kind of like back of the mind, like, hey, maybe it's in there and we're going to double check again?
Yeah.
Like, how does that work? Like, what do you...
I think that when you're looking at evidence like that, you have different tools to be able to look at all of the evidence. Your best tool is your client. And we often rely on clients. Hey, you're going to come in with the boxes and we're all looking at let's all understand they're not like as many physical boxes as we used to go through, although that is how we used to do it. I want all of the invoices from ABC Inc. And we'd all be sitting there with the Post-it notes and then making lists of all of that. And we had rooms full of briefs. You'd be going to trial and you had boxes and boxes and volumes. Yeah. Your Honor, I am at volume 8 of 105, tab C. Yes, and then everybody would pull up their tabs. But in going through all of that evidence, you want to know that you've gone through everything so that you get the best evidence, the best advice to your client. Yeah. And also, so I don't, misstate evidence to the court. I also have a court obligation that I'm saying there isn't an email anywhere that says this. I mean, I never say that because there's always a small chance some people do enough. When we're talking to young lawyers, don't say zero. Say, we have not identified yet an email. Do not say zero, okay? Because then it's going to be that one chance and that email comes out. I don't think we should say that. But I think that the client is the best tool because you know your business, you know how you operate, you know your team. Your members of your team who are also good pieces of evidence. You're
not doing this on your own.
Yeah, you're not doing this on your own. So the client is a really good resource for that. Obviously, I have a team. So, the hierarchy, you're not asking me to go through the boxes. Yeah. You're asking me to delegate that to somebody who's got like a quarter of my hourly rate because you don't want to pay me. And you have technology now, too. I mean, again, we're not working only with paper. We're working with I like to call it a paper light office, which is primarily scanned OCR documentation. We handle things, obviously, in a secure manner, but there are ways that you can use technology to be able to check, did that person with that email? Right. And algorithms to help you do that. And that's advancing and I'm going to say becoming more efficient for clients to get certain legal services because we can use technology.
Yeah, that's fair. And I know we had talked, it was a couple of years ago too, that you had sued some investment advisors, which I thought was super interesting. Because I've had some years where I had bad returns on my investments, and some years I had really great returns. And I didn't know that was an option to sue your investment advisor. And to some extent, like maybe the advisor's just trying to do their job and it didn't work out that year, you know? And so maybe walk us through that. Like, what are the common cases that you've seen? Because you've had a couple cases like that, right?
I have, yeah. It's a big enough part of my practice. And I think that for business owners and individuals, when you are successful and you have value either in real property or in cash or money, and you have an opportunity to invest that money, and you invest that value, that could be in a portfolio, that could be in insurance policies, that could be in real estate. There's diversity is key. We're not here on
investment advice.
I know we're not here. No, there's going to be another caveat on that. I do not provide investment advice either. But in those circumstances, you often rely on professionals. Yes, those could be lawyers and accountants, but yes, those are a variety of individuals who, call themselves advisors or financial advisors, which is not a
protected term.
It's not a protected term, but I appreciate that for the listener that they understand that it's an individual who provides them with financial advice. But there's a lot of regulation in Canada about investments. This is a great place to throw your money because you are well protected and well regulated. We have great banking services, expensive but good. You rely on your bank, you rely on a broker, on a dealer, you rely on an agent, you rely on the members, that individual who recommends where you put your money and what you do with it. But there is human error in that too. And those professionals break the rules by accident. Sometimes it's just by accident. All professionals make mistakes. But, if those mistakes cause you that you lost revenue that year, or you bought the wrong investment product and you maintain that investment product for decades, you lose on the profit, you lose money. Sometimes you lose liquidity on that. Sometimes you lose the availability to get it. Sometimes it's locked in.
They got you in on something that
Correct. You purchased something you didn't understand. You purchased something that was out of your reach. You purchased something you were not qualified to buy. You purchased something that its purpose and its goal was completely opposite to what the real purpose of that investment was. And if you are throwing money at investments and you don't understand any of the terms that I am using, you probably need a new financial advisor to explain that stuff to you. Or you should ask them. And if they can't explain the product you bought, if they can't explain why that product is suited for you or your business, because maybe you're corporately investing, which, again, talk to your accountant, your lawyer, or your financial advisor. But if you're not doing that well and you don't understand that, and the person that you are asking questions to cannot ask questions, you can pursue for investment losses. It's possible that individual is over their head. It's possible that individual made a mistake. It's possible that person has insurance to compensate that wrong, like a doctor or a lawyer. So there is an industry of pursuing financial advisors or banks or insurers on errors that they make to be able to recover money that you may have lost. And a good place to look is to ask questions to your financial advisors. The best advice I can have for you is to open your mail. I know, it's hard.
Simple.
It is so hard. I know it's hard. I suggest opening the envelope and, wait for it, actually taking the paper out. I know. We're going unfolding it.
Same thing happens with CRA. I know.
Oh, yeah.
People, same thing with clients. Yeah.
And then you read it. I get it. You may not understand, most of that, but let's read a little bit more than just the number on the last page is honestly the best legal information. I'm not saying keep a chart and graft everything yourself, but open your mail, check what's going on, know what you invest in. It's the first step into it.
Don't just check in 10 years later.
Don't just check in 10 years later. But yeah, it's possible for small businesses and for successful individuals to suffer losses that are not just caused by the market. And you should inquire and ask questions. And it's possible for you to recover those losses by pursuing the individuals who got you into that bad deal or got you in the bad sale or made you
Right.
purchase something that was unsuitable.
Okay. Well, no, that's great. Maybe a little question unrelated to the investments kind of side of things, but do you have any kind of controversial opinions or any kind of, maybe again, not advice, but any kind of like thoughts that are contrary to common kind of opinion, right? Like anything that from a legal side or whatnot that you're like, a lot of people think this, but really this other thing.
I think that there's two things there. The first is a lot of business owners want it all, which is great. And that's lovely. I'm supportive of that to a certain extent. And I think that that's the point, is you have to pick your battles, and you can't bite off more than you can chew.
Right.
And I think that a lot of, even in the legal profession and a lot in the business sphere would disagree with me, but there are certainly a lot of risks taken on chasing a bigger contract, chasing another project, growing.
Yeah.
When that either isn't scalable to the business or has not been planned out appropriately. And that opens up tons of risk. And that, it is maybe contrary to a lot of business advice. But on a legal standpoint, pick your battles, pick your projects, and that will protect you more. It is when you're overexerting your team that you make mistakes.
Right.
It is when you're overexerting your resources that you get into money problems. It is when you are asking too much of your subtrades, of your suppliers, of your manufacturers that they make mistakes. You have to change something that works really, really well because...
a new line of work or something. And then it's like, well, nobody knows how to do this.
Correct.
Yeah.
And you're right. The nobody knows how to do this is don't dabble. Don't dabble.
Yeah.
How hard is that? It's not like that's...
But it's fun.
You're like, I'm going to try something different. Back to don't fire somebody for the first time without asking how to do it. Don't start a business, an arm of your corporation in something you have no experience in an industry you've never touched on before.
Right.
Everyone who owns a small business, it doesn't matter where you are, you're in a regulated space. And to extend over the regulated space that you don't know about is risky.
Yeah. That's fair.
And so I think that that's contrary to what a lot of lawyers or a lot of, business consultants, might tell you, being like, well, you need to make more profits and you need to grow and you should expand. There's a difference between a dream and a goal.
Yeah.
I tell students that and then they look at me like I'm crazy. It's like, there is a huge difference between follow your dreams and follow a goal. Okay? Don't follow your dreams. We're not here to follow your dreams. Okay? We're here to follow goals.
Yeah.
Set realistic goals and then take that contract. Talk to the lawyer, expand, take another line of credit because you can afford it. Being able, it's when that growth component, that's when you're going to be knocking on my door being like, I can't pay all my bills. I have these 3 legal actions. People are chasing me. I need help. Or I have all of these clients who haven't paid me in 18 months and I'm having money problems. Okay, well, now you have legal actions where you have to chase the people who aren't paying you.
Yeah.
And you have the projects you're not continuing because you don't have the resources to continue or the manpower to continue. And then you have all of these other people, including maybe a regulator or the city or the crown or the province who are chasing you because you've breached all of these other rules.
Yeah.
So, to avoid legal problems, scale it is what my advice would be.
It's really interesting the way that you say that because I've seen it just from the finance side and it's interesting to follow ambitious business owners who want to grow quickly, who want to do new things that people haven't done before and it's interesting and it's stimulating and but that's where all the risk is. It's like when it's like the business coaches will tell you to 10x your business or to to grow into other areas and other jurisdictions and this and that. It's like, that's exciting, but that's where you're multiplying your risk. It's not just a little bit more risk. It's like
Correct.
That's where all of your risk will go to when you're going into a completely new jurisdiction with new people you're not used to, with new types of like it's just, and to multiply your business, and then you have the cash flow issue. Like it's interesting, and I see it just from our own clients that it's like they're kind of interesting to follow because they're like the cowboys, but then you're like, but when you're kind of like the cowboy, you're leaving so much like risk on the table that you're hoping certain things don't happen in order for your goals to be achieved, right?
You want to be the cowboy. I don't disagree with being the cowboy, but you want to make it to those end credits. You don't want to be the cowboy who gets shot in the first scene running away on horseback. I mean, you need, or the first one running into danger. I mean, you can be the cowboy, but maybe you should be the smarter, stronger.
Yeah.
You can be clever, you can be cute, you can have that ambition, but you need to make it to the end credits as the cowboy.
Yeah. Well, speaking of end credits, we're at the end. Great segue. So thank you, Margot, for your time today. I think this is a lot of fun.
Excellent.
A really fun way to kind of get through law, which I never thought I would say.
It'll probably be the only time you say it. Don't worry about it.
So how do people get a hold of you? How do people kind of like follow your journey? Is it LinkedIn, Twitter? What's your vibe?
Yeah, you can. MBC Law is the law firm. I'm pretty easy to find online.
Yep.
You can follow me on Instagram and you can follow me on LinkedIn. Of course, you can reach out. You can reach out by phone, by email, or follow me on social media. I'm happy to solve one small business problem at a time.
Sounds like fun. Yeah. So hopefully we don't have to see you, I guess, but that's
correct.
How it works. And if ever it's needed, then you're there. So thank you for joining us. This is a lot of fun. And hope you can come back at some point and we'll continue the conversation.
Thanks.
Awesome. Thanks.
Bye.